guys. All right, welcome. So let's see. So this is actually, so as far as the class name goes, this is actually the we're calling this a search and seizure show. And let me kind of share what the vision is, right? A couple of things. The first vision is to have a way for me to more easily answer your questions, right? So I get questions every single day from around the nation. I love getting them, but sometimes it's hard to answer the questions and so forth. So I try to make these YouTube videos. I think you guys have seen those, right? Some guys have seen the YouTube videos. I'm going to keep doing those. Those aren't going away, but it's just I can't make those fast enough, right? Because I usually make those from the studio or on the road, but that's fine. I'm going to keep doing those. But I also want a way to kind of go through several questions at once. Hold on. Motel 6. Hold on. Am I back? Sean, are we good? Okay. The internet actually does kind of suck here. It's not the Motel 6, though. I don't really like Sean saying that. It's the Red Roof Inn. So we're going to answer some questions. Now, here's the other thing, right? I would love for you to be able to ask questions too. Like, hey, Anthony, I got a scenario. Let me run it by you, right? Very funny, Nate. I'd like to, we can turn on mics. Now, remember, I cannot see you. I cannot hear you. But if you want to ask a question, that's what this is supposed to be for. I think this would be fantastic, right? That you guys can hear other people like, hey, let me ask you something. I had a situation involving XYZ. What do you think, right? Now, this is going to be for, it's going to be for search and seizure questions. If it's law-based, meaning, is it a question about statutory interpretation? I may not be your guy, right? But if it's search and seizure based, I can definitely help. All right. All right. So make sure that you select everyone on your chat settings. It looks like everyone is doing that except Andy. Nobody saw that, just FYI. And John, those are the two ones I see so far. All right, so make sure you select everyone. Otherwise, nobody can see your messages except me. All right. So for those, anybody new here today, say me. And I also got okay. What's up, Andy? All right, cool. I got a poll for you too, by the way. So let me do this poll. I just want to let you guys know that this video will be recorded for YouTube. Okay. So if you're going to be like, hey, I would love to see this later, or, this is some information I want to see my other guys to see at work, I'm going to post this to YouTube. All right. All right. So Rick, if you want to send that in the chat, go ahead. Because this is going to go on YouTube. So you can also send it on the chat. Hey, I'm also going to launch a poll real quick. I kind of have a couple questions I want to ask you for going forward. While you do that, I'm going to introduce myself. My name is Anthony Bandiero. I'm an attorney and senior legal instructor for Blue to Gold Law Enforcement Training. This is what I do for a living. I have the honor and the privilege to train police officers all around the country in search and seizure. I have a dream job. I love what I do. And I was a former retired police officer out of Nevada. So worked in Las Vegas most of my career and so forth. So I'm glad you guys are here. And I know it's a little bit short notice. So we have a decent number of people here, but I know it's a little bit short notice. I'm also asking you guys, when would you like to see these webinars in the future? Interesting. Well, Wednesday and Thursday are a little bit neck and neck, right? But evening is good. That's actually the best time for me to do them. So keep doing those that poll. All right. We still have some people that haven't done it yet. All right. So that's a little bit about me. And if you're on YouTube watching this, welcome. I hope you get something out of it too. The book, right? I'm the author of the Search and Seizure Survival Guide. It is, I'm proud to say, the best-selling search and seizure book in America, right? That maybe not be hard to do, right? It's not like I'm competing with, New York bestsellers. It's on my Amazon rankings, it's right underneath Cooking with Arsenic, right? But it's a good book. A lot of cops love it. And cool. Thanks, Corey. So it's a good book. I hope you consider getting it. It's on the website, bluetogold.com. And I think it'll help you a lot. All right. We're going to talk about latest search and seizure questions. I have a list right here. I'm going to show you what the question is. I'm going to give you some background. And then we're going to have an open forum. Okay. Okay, cool. All right, Rick, I'll show you the university. Excellent. And make sure you remind me too, Rick. All right, so your questions. I could not even get remotely to all of your questions. So I'm going to keep doing these shows until I get caught up, and then they're going to be like once or twice a week. All right. Let's see what Andrew has. This is what this is for, right? This is the interactivity. So Andrew says, in another class, a case was brought to my attention regarding the duty to intervene and entering a private residence in a case of or threat of self-violence. DeShaney, yep, Winnebago County. What are your thoughts regarding an officer's right to enter a private residence due to a threat of self-harm? Okay, so here's what's going on. First of all, let's talk about DeShaney versus Winnebago, right? The principle established in that U.S. Supreme Court case is that police officers have no duty to protect people from harm, okay? What that simply means is that, let's say that that police officers get a call that a home there's a home invasion. And look, they are, deficient in their duties, they're negligent, or they're farting around in the station, and they just do not get to the call, right? They could have saved somebody's life. If they would have just left the police station and beelined it over to the house, they could have saved the homeowner. But instead, their, lack of due regard for people's safety and just messing around, helped the person died. Can the family of the decedent sue the police officer or officers or agency? The answer is no. Okay, not under constitutional law. There is no constitutional right to have police protect you, right? So it might be morally wrong, ethically wrong. The police officers may be derelict in their duties. There might be a state statute that comes into play, but not constitutionally. Now, that brings you to Andrew's question. So if we have a person who's threatening self-harm and we just, don't enter and we leave a door tag or something with an 800 number to suicide prevention, can we be sued? And the answer is generally no, right? The cops have no obligation to save that person from themselves. Now, what are my thoughts regarding an officer entering a private residence due to threat of self-harm? I'm going to tell you what I think, and you are completely, at liberty to disagree. I believe that most of the time when people are threatening self-harm and there's nobody else in the residence and there's no other, facts or circumstances to believe that the neighbor or somebody else will get hurt, I believe that if they do not want help, they're saying, leave me alone. I believe that police should leave. I believe that police should put a door hanger on the door and say, these are the resources that you can have. They're all free. They're all available to you. Because the problem that I see is it's kind of a lose-lose situation for police. Number one, the reality is this: most people will not commit suicide, right? Most people will not commit suicide. Most people threaten suicide, but ultimately are not able to go through with it. But I do know that when cops confront people who are suicidal, sometimes they will challenge the police and basically have a suicide by cop situation. So then the cop is basically forced to do the job that they can't do themselves. I'm almost wondering if more people are dying because of suicide by cop than if they would have died being left alone. I'm wondering I would like to see statistics on this. I'm wondering if more people that would have never killed themselves are actually dying because they use you as a solution. And then the second thing is, now that they've been shot, killed, whatever, the family sues you because they say you did the wrong thing. You didn't de-escalate and all this kind of stuff. So my opinion is that we need to kind of back out of these situations more often. I think we have LA here. I don't know if LAPD is here. I have heard that LAPD is instituting this kind of policy, something like this. And if you know the answer to that, I would like to know the answer. If you know of another agency or your own agency does something similar, I would like to know. But that is my opinion on the situation. So there's the legal standard. There's no duty to help people. And secondly, I think that sometimes it just ends badly and we should just pull out. Now, look, this is not a one-way street. Do you disagree with me, agree with me, or have a different point of view on it? Please put it in the chat. I would like to know. Also, if you have something else and you're like, hey, I'm a crisis counselor, I'm CIT, I would like to, you want to add something to the context, please. If you want me to put on your mic, I can absolutely put on your mic, right? Hey, Mark, what department are you, Ellie? What department are you with? Are you Sheriff's Department? I forget. No, Laverne. Okay, got copy. So the problem in those instances when a person who has a mental issue and comes out with a handgun out in public just to confront cops because they want to commit suicide by cop, absolutely. So, all right, our first question, okay, of the day is, can you enter a home to retrieve clothes for an arrestee? Okay, let me, so I have these all printed out, okay? So let me kind of read what's going on here. Yeah, exactly. Okay. Yep. All right, cool. All right, Patricia. All right, excellent stuff. All right, let me read the situation. All right, so this comes from an officer from Arizona, right? Officers were dispatched to an emergency call about a stabbing, that the girlfriend stabbed her boyfriend, right? Upon arrival, the officers locate the complainant / boyfriend, and he has a laceration on his left arm. So not a serious cutting, stabbing, but nonetheless, obviously, this is a very serious crime, right? Non-life threatening injury. The fire department bandages the guy up, and he basically says, hey, look, he met this girl on a dating site approximately 6 months ago. All right, I see where this is going. All right, she's probably a little crazy. All right, I got you. I got you. You met her. If she's on a dating site, it's because nobody else. Maybe she's having a problem finding a good man, right? Because she might be a little crazy. So I'm kidding, Allison. I'm kidding. Not really. So they've been casually hooking up. And he has been seeing other women on the side without her knowing. Oh, snap. This is about to get real. So she's looking at his cell phone and finds the pictures, right? So they both have been drinking and so forth, but they're not blackout drunk. And she starts screaming and so forth and tells him to get out. Well, she's holding his cell phone, and he says, hey, I will leave. This is her house, her apartment. I will leave, but I want my phone, right? And she's not going to give the phone back. So he tries to grab and retrieve his phone, and that's when she cuts him. She gets him. She cuts him deep, right? And then he grabs her phone, flees the apartment, and calls 911 with her phone. So they arrive, this is, they get the whole story. They go up to her door, right? And they look in the window and they can see her watching TV, right? A good slasher movie. She's like, man, next time I got to do it right, So they knock on the door. She comes to the door and she corroborates, that she corroborates that she did this. And so they arrest her for domestic violence. Now they bring her outside and she is in a nightgown with no underwear, no bra. It's, a skimpy outfit, according to, basically the cop. And they don't want to take her to jail because number one, they have to process her at their police department. And then when they take her to county, they have the jumpsuits, but they have no clothing for prisoners at the police station. So the question is, right? Oh, I'm sorry. Well, I guess the question is number one, can we go in to grab clothes for her? And number two, if we ask for consent, if we say, hey, do you, or they ask her, hey, do you want to go in and grab some clothes? Can they follow her in and, watch her while she's grabbing her clothes? So let's go with the easy one, right? If they ask her, hey, do you want to go back in your apartment and grab some clothes, shoes, belt, jacket, whatever, can they follow her in? Right? Right. 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 All day long, right? All day long, right? This one is actually very, very easy. You can absolutely follow people into the house and, as one court said, elbow to elbow while in the house. Okay. So that's the easy one. Now, what would happen if she says, no, I don't want you in there? Or I think in this case, actually, they actually went in there. Well, anyway, this one's a little complicated about that part. But what if she said no, right? And you can't go into my apartment, but she's going to be exposing herself at the jail. There's other people there and so forth. What about that part? And then it's going to get cold. Yeah. Yeah. So here's the deal, right? Yeah, I'm kind of with you, generally speaking, that look, if she has some clothes on, we do have like emergency blankets, right? Those aluminum blankets. I think that's the right answer. In order to get back into her house without her consent, you're going to need some form of exigency. Now, if she is naked and you just need clothes for her, or you don't have a blanket or something like that, I think you're going to have to do what you're going to do. I think that the courts would understand the urgency of the situation to go in there and grab some kind of blanket, right? But hefty bag overhead. There's a tough crowd over here. It's a tough crowd. So here's some feedback from the great Wayne LaFave, who is the most recognized search and seizure expert in the nation. If the defendant is placed under arrest at a particular place in the premises, even at the front door, the circumstances may be such that he will be allowed to move about the premises prior to departure for the police station. Although this may occur for other reasons as well, it occurs with the greatest frequency when the defendant needs to change his clothes or put on additional clothing before departing. Often the defendant will ask that he be allowed to do this, although on some occasions it appears that the police have been the motivating force in causing the defendant to seek out other clothing. So that's what we kind of have here, right? That the police are saying, hey, look, I can't bring you to jail in underwear. I can't bring you to jail with no shirt on if it's a female and so forth, right? In either event, the courts have had little hesitancy, right, in holding admissible evidence discovered by the police as a consequence. So, look, you hear what he's saying, right? Generally speaking, usually the prisoner is the one, wanting to go back into the house. However, if you have the right facts, if you have a situation which could cause a disturbance, you're going to bring them into the jail. You don't really have the blanket situation. You don't have blankets. You don't have other clothing. There's other males, prisoners at the holding facility. They're going to cause a disturbance, and she's potentially exposing herself. I think you got to use good judgment, and I think if you have to go back into the house, I think the court will uphold it if you can articulate that. Here's another quote. None of these practices seem inherently unreasonable, right? And thus, it is not surprising that they have all been upheld by the courts. Where the police have done no more than accompany the defendant to another part of the premises, resulting in their observation of evidence, it need only be determined that the police were lawfully present where they made the observation. Courts have rarely accepted the proposition that to prevent escape and for self-protection is lawful. So accompany the arrestee. We do not have, a lot of cases. I have not seen a lot of cases where the only reason that the defendant is not agreeing to get the clothes and the police are going in anyway. It is going to be the exception to the rule. Okay. You're going to have a legitimate reason, some form of urgency, right? To go and get some clothing or a blanket. If you don't have that, stay out. Okay. So the takeaway here is this: officers may follow an arrestee into the home and search objects being removed. If no consent is given, then cops need exigency. Any questions on that? Hopefully that helps, right? Hopefully that helps. All right. So there's that one. One down. Okay, the next question. Okay, can cops re-enter a home? This is bad English, but can cops re-enter a home to seize evidence seen inside the home initially? Okay, let me kind of give you the background here. Okay, hold on. Okay, here it is. Where's this officer at? This officer is from Indiana. I believe it's Indiana. Okay, so, all right. So the officer says, look, Anthony, I remember you talking about, this officer's been to my class, right? I remember about you talking about how there is no evidence exception to a search warrant, right? In other words, you can't process a crime scene just because there is a serious crime at the home. And I remember talking about Mincy versus Arizona and about how processing the crime scene over 4 days was unreasonable and that they should have obtained the warrant. But that decision doesn't specifically mention 4 days. Well, we learned later that the backstory is that it did. In fact, I think it did mention 4 days, but that's besides the point. It just says that there is no further threat of harm and the crime itself doesn't create the exigency. So they should have obtained the warrant. That is absolutely true. So here's the situation. I went to a family violence call with another guy, right? 2 brothers are fighting. They both live with mom. They share a bedroom. Okay, that sucks. The one brother throws a fairly heavy Bluetooth speaker at the younger brother, and it strikes him in the side of his body, right? They then get into a physical altercation. Younger brother calls police. We get there, interview, partner decides to hook the older brother as the primary aggressor. We see that while we're in the house, we see that the Bluetooth speaker is on the younger brother's bed, the one that he threw, where it remained after the other brother threw it, right? The partner takes the brother downstairs and arrests him there because the mom is very upset and doesn't want him to go to jail. The partner comes back up the stairs after another unit, back into the house, it seems like, and after another unit transports the suspects for us, right? So it looks like, I'm going to assume here that the cop left the house, came back in, and he wants to take the Bluetooth speaker as evidence. Now, I said that he couldn't just take it without a warrant. Now he decides to just call it, split the difference and just take a picture of the Bluetooth speaker and leave. He's not sure if he can take it or not. Now, and a soon to be sergeant is arguing with me now, saying that we could take it under a case called Chimmel versus California. That's a U.S. Supreme Court case. He argues that it's in the area under the immediate control, and therefore we can search for evidence and seize it to prevent it from being destroyed. I argue that it wasn't under his immediate control since he was interviewed in the living room and arrested outside, downstairs, and so forth, right? And that there was no threat of the evidence being destroyed. Now, help me out here. I think the soon-to-be sergeant has a valid point, but maybe it's actually somewhere in the middle. Okay, it's somewhere in the middle. Okay, first of all, let's decide the easiest case here. Chimmel does not apply here, right? Chimmel only, the officer is absolutely correct. Chimmel only applies to those areas under the immediate control of the arrestee at the time of the arrest. If he was formally arrested, even in the hallway, that Bluetooth speaker is not within his immediate control. So we're not going to be able to grab it under Chimmel, okay? However, we can grab it under, sorry, I gotta get the slides up there, right? We can grab it under plain view, okay? So if we are lawfully present and see evidence that is, or see an item, I should say, that is immediately apparent as evidence, contraband, fruits, or instrumentalities of a crime, you can seize it without a warrant, okay? As long as it's immediately apparent as such. Here, we know the Bluetooth speaker was the item used for the assault, right? It is evidence. Whether or not, look, if we go downstairs and arrest him and we go back up to the bedroom and seize the evidence, it makes no constitutional difference, because here's why. The cops have already entered the home lawfully for the purpose of investigating the domestic. So the fact is, they're already present. The fact that it's in a room and they're downstairs is of no constitutional consequence, okay? They're not making another constitutional entry in order to seize the evidence. All right, Anthony, but what if he left and brought him to a squad car, or handed him off to another officer on scene and went back into the house? Well, that one gets a little more tricky. However, generally speaking, if the action of leaving and re-entering is, quote, continuous, then we're good. If there is a unreasonable delay, right, then you can't re-enter the home. You're going to need some kind of consent from the mom, who may not give it, or you're going to need a warrant, okay? Let me read you some stuff. We cannot say that this is an example of just re-entering a home. So if you're already on scene, I'm sorry, if you're already inside the home and you know that the evidence is upstairs, then that's an easy one. It's not chimmel, it's plain view. Does that make sense, guys? It's not chimmel, it's not search incident to arrest, it's plain view. But if you're going to leave and come back in, this is kind of some guidance here. This is the closest case I can kind of find on point in the short time that we had. We cannot say that the second search of Voss's room was unauthorized and that the evidence tendered and admitted was the result of an unlawful search. The time which elapsed between the arrest, the immediate search, and this second search was of such short duration that we are justified in holding that the second search, the entry, okay, was merely a continuation of the first. It cannot be considered as unreasonable in any legal sense. Okay, so the takeaway here is that cops can always grab and go plain view evidence while inside the home. A reentry will be judged on whether it was continuous. Okay, if you are, I'll give you an example of not continuous, where in one case the cops saw plain view evidence, left the home, nobody's inside, waited for detectives to arrive, then re-entered the home. That's not continuous. That re-entry was deemed to be unconstitutional. Okay, does that help, right? Now, let me see give you some feedback on that. Hopefully this is helping. I think I plan to do these every week in addition to my other webinars, right? My more structured webinars about consent and curtilage and vehicles and all that stuff, because I think this is to tie up some loose ends, right? Let's tie up some loose ends. All right, cool. Lance, what about following up on a hit and run? You track down the vehicle and it is in the driveway of a residence. No one answers the door of the home. Can you take the vehicle as evidence without a warrant? I got your answer. Okay, well, actually, you tell me, right? Can you take the car? Yes or no? Okay. Okay, the answer is no if the car is on curtilage. Okay, the answer is no if the car is on curtilage. If you believe that driveway right next to that home is a piece of that guy's curtilage, not just property, but curtilage, you cannot take the car due to a Supreme Court case called Collins v. Virginia. Okay, you can no longer seize evidence like a car while the car is on the person's curtilage. In Collins, the motorcycle was stolen, but it was in a carport. The carport was deemed by the U.S. Supreme Court to be curtilage. Okay. And you can't go on the guy's curtilage and seize the car. He does not have, in the case of Collins, the bike was stolen, and he does not have an expectation of privacy in the motorcycle. He has an expectation of privacy in where the motorcycle is at, which is curtilage. So there's your answer. No, if on curtilage. Okay. You're welcome, Lance. All right. Question. I have two homeless. I have two homeless who have found a business suite unlocked and brought all their goods into the suite. I don't blame them. You know what I mean? They are noticed several nights later by somebody and calls the police. The homeless comes out, but their property is inside. One homeless has a warrant and is arrested for it. The other is let go, but police go into the suite because the property manager wants the homeless out, the property out, right? Police find drugs in a makeup case wrapped up in a brown plastic bag inside an ice chest. Is that a good search and seizure? Probably not. So, I mean, we can go both ways on this, right? We can go both ways on this, but look, here's the problem. Here's the problem that we have, okay? Number one, do they have any expectation of privacy in the area where the evidence is found, right? They have no expectation of privacy, in the, in the place because they're squatting. However, do they have an expectation of privacy in their own containers? And I think the answer is yes, right? I think the answer is yes. Hold on. Now he says, but if he now knows it's stolen but doesn't give consent, he is now knowingly possessing a stolen vehicle. Oh, hold on. That's something else. Okay. Let's break that up. Okay. So there is a case out there though, where, some kids broke into a house and they were called out by police and they left the backpack in the, in the house, and the cops searched it and found a gun. And the court upheld it. But I think what's going on there is that, they're involved in a pretty violent, like a burglary and so forth. And I know this is probably going to be considered a burglary too. That's why I can go both ways. But I think because the cops are going to let this guy go, and he's probably going to be allowed to take his stuff with him, I just don't see in this fact pattern how he would lose his reasonable expectation of privacy. With the other one, with the house and being called out, by cops, and they're all going to get arrested, I just think it's a little bit different. All right. So I think Jason is kind of follow up with Brian saying, Carol Docton, does it still apply if the vehicle is not on curtilage, but no driver is present and plain view evidence or odor is found? Yes. Collins only applies to curtilage. If the vehicle is on open fields, public property, street, whatever, and you have probable cause, the Carroll doctrine applies, which allows you to search it with no more, right? Probable cause plus readily mobile vehicle. All right. Okay, so next one. Can a passenger be arrested for giving false ID to the police? What do you guys think? Can a passenger be arrested for giving false ID to the police? Okay, so here is my fact pattern. Look, so it looks like they stopped the car, right? And they asked the passenger for his name. And there's no investigative reason, but they are just asking for it as a matter of routine. The guy provides false ID, right? They know that this is not him, right? And they have probable cause that he's not giving his real name. So can we arrest him? Here's the answer, right? It all depends on your state law. It's not a search and seizure question, right? It's a state law question. This officer is from North Dakota, and unfortunately, I do not know North Dakota law well enough to know whether or not this violates North Dakota law. This question, if some states say yes, it's illegal, other states say no, it's either way not a search and seizure issue, right? Pennsylvania versus Mims does not apply here because that Pennsylvania versus Mims basically says that the drivers can be taken out of vehicles for any reason, right? And so, look, I do have an example in Texas, right? Defendant who was a passenger in a vehicle, subject of a traffic stop, was lawfully detained when he gave police officer false identification, as required to support conviction for intentionally giving false name to a police officer while lawfully detained. Police had observed the vehicle parked in such a manner that it was a violation of city ordinance, which violation was legal basis for stop. And once vehicle was stopped, all persons within it vehicle was detained. So in Texas, the answer is yes. I just do not know if it's illegal in North Dakota. All right. All right, Misty, you want the you want to be on the mic? You're raising your hand? You want to put the mic on so you can actually ask your question? Is that what you're doing? All right. So in the meantime, Misty, let me know if that's what you're looking to do, because I want to get people talking on these webinars more. Okay, sure. So let me answer Michael's question first, and I'm going to put we're going to turn your mic on. You can ask your question. This is great. This is what I really intend for these long term, is that most of these questions are going to be live. In fact, if I get these questions, through my email, I'm like, hey, can you talk about this on the webinar? All right. Any thoughts on the court's hammering extenuation of a stop by asking for someone to identify themselves while seized during a traffic stop? Michael, you're my, I'm forgetting here, but you're my Metro guy, aren't you? So I have my Las Vegas Metro guy. Here's my opinion on it. So let me just tell you background for my people attending here, for those who do not know. Nevada, specifically Las Vegas, has gotten hammered lately over asking passengers for their IDs, okay? So let me tell you about one case, right? The first case I want to tell you about, the first case I want to tell you about is where an officer, in Las Vegas stopped a car with, Michael can correct me if I'm wrong, but I think it had 12 Mongols in it as a passenger, like a crew, a work van, whatever you want to call it, with 12 Mongols in it. And the officer, got other people out there, backup officers, and he basically asked for ID from all 12 passengers. And this took a long time to get the IDs, to run them all, and et cetera. They turned around, right? Yeah, and then also it looks like a command, right? Is that right, Mike? It looks like a command. First of all, okay, well, look, if it's a command, you're done, right? If it's a command, you're done in any state. You cannot demand ID in Florida, Texas, Nevada, California, because they have done nothing wrong, right? So hold on, right? Okay, yep, so good. So, but here's the other problem, okay, Mike, and this is another background. Even if the Metro officer would have politely asked, hey, Mr. and Mrs. Mongols, can you please provide your IDs for this nice officer, right? So I can run you. I still think we have a problem, right? Because it's still unrelated, right? And it is measurably extending the traffic stop. Now, I know that the Ninth Circuit has gone a little crazy over, not crazy, that they're hammering, some like Landeros is a case out of Arizona where the cop demanded ID and got hammered on that. But, look, asking for 2 IDs, 3 IDs, maybe even 4 might be permissible, but you're pushing it, right? But asking for 12 IDs and running these people is completely unrelated to the traffic stop. It is extended traffic stop by a measurable amount. And I think that the court in that case, whether demanded or asked, got it right. So Mike, you agree with that? But now let's talk about the latest case that came out let's talk about the latest case that came out of Las Vegas. Here, a Metro officer simply asked the passenger for his ID, asked, not demanded, asked, and it took 40 seconds. And the court said that was a violation of the Constitution. I 100% disagree with that. That is not the law in I do not think that's the Supreme Court's interpretation of unlawfully extending a traffic stop. You can kind of read some cases and get that interpretation in extreme view, but thousands of court cases have upheld talking to passengers during a lawfully traffic stop and never held that that was in and of itself a violation. That case is being appealed. Okay. When I teach in Nevada, I talk about that case, but I'm letting them know that I think that there's light at the end of the tunnel. That is not good law in my book. Mike, does that answer your question? So the Mongols case, I think is correct. This new case, I think is incorrect. Okay, and I think that's going to get overturned, in my opinion. All right. Hopefully, Mike. While the driver was looking for their paperwork. Oh, so you even have a double whammy that's in our favor. That this is called multitasking or unavoidable downtime, right? There's not even an extension of the traffic stop in that case, but they added it as 40 seconds. And they also said that it was, unrelated and all this other stuff. All right, we're gonna do Misty next, and I want to hold on. Okay, Misty, let's hear what you have to say. Okay, let's do it this way. And if the dog's barking, that's fine too. But hold on. Hold on. Where's? There you are. Okay. Misty, now it's on your end. Approve the microphone.
Okay. Can you hear me?
Yes.
Yes. Okay. My question is with the vehicle exception for search being the fact that it's mobile, what is our time frame after getting probable cause that there's evidence of a crime in the vehicle? Is it continuous with the investigation? Can we have a little bit of a gap in time due to the reporting party failing to contact the police immediately? Just curious if the court's established the lapse in time from gaining probable cause.
I definitely, Misty, I got your answer. Just verify with me though. What state are you in? Just to make sure if I know anything different.
California.
Oh, I definitely no. California is legit, actually. Okay, so I got your answer. Is that? Do you have anything else to add before I answer it?
No, we had two different situations of it, but no, go for it.
Well, okay. Why don't you stay on the line just in case I say something that you want to clarify, like, oh, that's not quite what happened here. So
okay,
here is your answer, and it's clear as day. There is no time limit on these car searches. Here's why. In order to search a car in California or in the vast majority of states, I do have some cops from Pennsylvania, New Mexico, New Jersey. Here, they're a little different. But in your state, I absolutely know the law in your state. In order to search a car in California, there's 3 requirements. Number 1, probable cause. Number 2, the vehicle's not on curtilage. We talked about that. That's Collinsville, Virginia. Number 3, the vehicle appears readily mobile with little to no repair. And number 4, when you conduct a search, you search it in the same manner as if you had a warrant. It does not really matter that cops waited to search the car. It does not matter that the cops had probable cause at 8 a.m. and come back at 8 p.m. and search the car. All that matters is that probable cause still exists. Now, we may have a staleness issue. We may have other issues where the evidence could have been taken and the cops should have known better and they would have never got a warrant. But at the end of the day, the question is this. It's not about time. It's about, could the cop, if he wanted to, if she wanted to, go to a judge and convince the judge to give them a warrant. If you think the answer is yes, that car is 100% searchable under the 4th Amendment in California law.
Perfect. Clears it right up.
Okay, good. Then we're good. All right, thank you.
Okay. Thank you.
You're welcome. All right. Let me turn off Misty's microphone. Hold on. You can turn off on your end too, but let me just kind of disconnect you from 1 second, Misty. Okay. Oh, here we go. So, okay, Misty, now your microphone is totally off on my end too. All right, so let's see what we got next. Let's see what Brian says here. To clarify my earlier question, if you have the stolen motorcycle under the carport, you go and knock and the homeowner says something like, my buddy left that here. You tell him it's stolen and on his property, but doesn't give consent to retrieve it. Is that owner now knowingly in possession of stolen property? I think so, right? I think the answer is yes. And you're going to have to talk to your prosecutor. There is a prosecutor here, and I forget what the prosecutor's name is. But if the prosecutor wants to give his or her, I think it's a her, but her 2 cents on this, I would love to hear your point of view. But I think the answer is yes, because possession of stolen property is knowingly possessing stolen property. Well, they know about it. They're in possession because it's on their property and it is stolen. So I think the answer is yes. Nate says, how do you know the motorcycle is stolen without running the VIN? Well, if the plate comes back stolen, that's probable cause. You don't need to verify with the VIN. That might be certainty that the bike is stolen, but a license plate, even though there might be other circumstances that we know the bike is stolen. So you don't need absolute certainty for probable cause. All right, hold on. Let's, okay. Damien or anybody else want to go? I like people to go live on the mic. I think people enjoy that, by the way. I think people like Misty talking and, you know, hearing other people on it and not just reading these. And also don't forget that we have YouTubers. They're going to watch us later. Will anybody want to be? Okay. So Damien, let me answer your question. So Damien says, and then hopefully the next person that has a question, I would like you to see if you have a mic. I really think that's good for us cops. Okay. Officers are observing a known drug house with a vehicle located in the driveway. The registered owner has a warrant in the vehicle. Okay. There is a passenger in the vehicle. Both occupants exit the vehicle and are contacted. So far, so good. The driver is arrested and searched. Drug paraphernalia is located on his person during the search incident to arrest. The passenger remains on scene and next to the officer of his own free will, and he's not detained. She is then detained upon evidence located on the person, the driver, and based on her seen exiting the vehicle, you know, and with the officers and so forth contacted. The search of her person bag is conducted. Drug paraphernalia are located. She is arrested. Search of the vehicle located more contraband. Is this search of the passenger her good? No. I don't think it's good. I don't see, I just don't see it. I don't see how the cops have probable cause for her simply because she is hanging out with a drug user, right? I don't see any history as to her. I don't see her guilty mind evidence. I don't see her making admissions. I don't see them passing things to each other. I just don't see it. I think that's a bad search, right? Hopefully that you know, you. All right, let's do one more. Steve, not one more, but Steve, Star Chase, right? That's that GPS with the sticky part, goes onto the car, is being used by our agency as an alternative to pursuit. A warrant is required to use a GPS device to monitor suspects, but under these circumstances, we do not have time. If we deploy it, should a warrant be sought after for its use? And does this change with a stolen vehicle? Yes. Okay, so here's the deal. Number one, these Star Chase devices are absolutely good to go under what? Exigency, urgency, emergency, right? Cops do not have time to go get that warrant. Now, because this is hot pursuit and they're going to let the car go, you know, in its neighborhoods, whatever, you don't need to get a warrant at this point. Okay. If the car is not stolen, you only have to get a warrant when the cops have time. And if they're actively tracking down this car, there is no time. So there is no warrant. If they lose the car somehow, you know, then I guess go get a warrant. But I just don't see a lot of warrants in these cases. I think cops are going to be pretty much tracking down this car actively, and I don't think you need any warrant. Does this change with a stolen vehicle? Well, if it's a stolen vehicle, then the person has no reasonable expectation of privacy in the location of that stolen vehicle. So even if a warrant was required, you definitely don't need one if the vehicle is stolen. Steve, does that answer your question? Okay. Good. Jason. No, Jason, that didn't go to everybody. But let me ask the question, okay? Can an agency have a broad blanket policy for employees in reporting any prescription medicine? I realize that there's a reason, but that would encompass, for example, antibiotics and less relevant medication and so forth. Is that a medical inquiry under the ADA or good to go? No idea. Absolutely no idea. I wish I knew the answer. I'd be lying and making up stuff if I had an answer for you under the ADA. I just don't. Okay, Dalius, do you want a microphone? No mic. Then spit it out. While you're doing that, let me let me try to go through one more case. Okay. Takeaway for that last case I talked about here, right? It is likely that this is against your state law, giving false information to a police officer, right? When they're being seized. But you're going to have to verify that since whether this is a crime doesn't depend on the Constitution, but on the statutes, right? All right. What about this one? This is probably applicable to some of the stuff we've been talking about. Can we search a car for ID after evaded police? The answer is yes. Okay. Here's what happened. So we had a vehicle evade us. This is a cop from Texas. We had a vehicle evade us, right? And we end up finding it like 15 minutes later, but the driver had already fled on foot. The car was lawfully parked, right? And lawfully parked, the doors closed. An officer opened up the car and started looking for identification about who the suspect was. We've been going back and forth on this, mainly talking about whether or not identifying info is technically evidence of an offense. Was hoping you'll be able to provide some clarification. The answer is we're good. Okay. We are good. Because here's the deal. There's all kinds of reasons to get into that car under these circumstances. Number one, identification is evidence, right? Identification is evidence. Also, there's also exigency, like legit exigency, to identify this person. Because look, if you've got a bunch of people, walking around and so forth, how do you know who this person is, right? I mean, you can't start detaining people that happen to be in the area without, unless you have something more. So if you can find out who this person is, then that will give you, the ability to detain them soon. If we go get a warrant and come back, that guy's long gone, right? And so the great questions, people say, hey, Damon's like, what if the doors are locked? And Michael, can we use a lockout kit? Yes, absolutely, right? I wouldn't smash the window. I wouldn't damage people's property, right? Now, I wouldn't do it. But can you use a lockout kit? The answer is yes, because the question is, would a judge allow you to use a lockout kit? And the answer is yes. Remember, that is part of a motor vehicle search. You search it in the same manner as if you had a warrant. If the warrant will allow you to use a lockout kit, use a lockout kit. Okay. Let's see. Sean, trash pulled out for pickup by curb. Is this abandoned property, or is it a constitutionally protected? Iowa just passed a requirement to get a search warrant in order to pull trash. Okay, well, there's two issues going on there. Number one, is it constitutionally protected? Not by the Fourth Amendment. That case is California versus Greenwood. Okay, in that case, the U.S. Supreme Court said that trash put out for collection is no longer protected under a reasonable expectation of privacy. They are giving it away. They're expecting that scavengers and animals and the trash people are going to pick it up and take it away. No expectation of privacy. However, state law can make a higher burden. So if Iowa wants to protect it under state law, then it's statutory, but don't say it's constitutionally protected. Now, some states like Oregon and New Mexico protect trash under the state constitution, but that is a different issue. That's not the Fourth Amendment. Sean and everybody else, does that answer that? Okay, good. All right. Is it Chi? Let's go. Let's ask this question, right? Contact is made with a suspicious vehicle at a gas station called in by a citizen who witnessed the driver and front passenger asleep in broad daylight. The driver and passenger come out of the vehicle when the police arrive. Police explain to both of them why contact was being made, and after they produce ID info, the driver is arrested for warrants. The passenger hangs out waiting for a ride. The vehicle is inventoried, and a lunchbox on top of the center console with the driver and the front passenger is found containing drugs. The driver said it was not his. The passenger said it was not his. Now the passenger is arrested because the lunchbox with the drugs were in close proximity to both subjects. That should be a good search and seizure, right? Well, yes, as far as the search goes, right? Let's talk about the arrest. The arrest is good. The arrest is based on constructive possession, but I want you to know something. I'm not sure you're going to get a conviction, right? Arresting somebody for being in a car where contraband is found is one thing, but in order to convict, you have to prove beyond a reasonable doubt that they had the intent to exercise dominion and control over the contraband. Simply being in a car is not enough. So what I like to say here is this will get you the ride, but it beats the rap, right? You know, yes, it's a good arrest. There's a fair probability, that's probable cause, that the passenger is also involved in narcotics, but you're going to need more. Let me tell you how you get more. Number one, guilty mind evidence. Is the passenger acting abnormally nervous? Does the passenger have a record? Is there plain view, plain smell? Does the passenger own the container? Do you have indicia of control on the container? Does the passenger have an arrest record for this type of stuff, right? Is the passenger being deceptive? Is the passenger lying about stuff? That's how you prove these cases, right? Okay, let's go. Mark, let me answer that in a second. Let me go to Dallas. That's a great name, by the way. Dallas is just a great name, right? All right, so multiple officers, most of them, which much more experienced than me, almost always search the person after citation is issued. Oh, for drugs, right? I could see maybe after a retail theft to retrieve the stolen goods. That's true. But quite a bit will search the individual right after before a citation is issued, claiming that the citation is an arrest. What is the citation for? I got to know this, right? Before I answer this question, what is the citation for? Speeding? Pedestrian violation? Kind of confused here. When are some examples of when you could search incident to arrest when a citation is issued? Hopefully that makes sense. It makes total sense. But Dallas, okay, no. What state are you in? What state are you in too? Okay, Texas. All right, look, Utah. No. That's a blatant violation of the Constitution in my book. Hey, by the way, actually, Ricky brings up a good point. I'm at a hotel in St. George, just so you know. So I'm in St. George, Utah, delivering a class. And hold on, it's not Hurricane, Utah, it's Hurricane. Okay, guys, get it right. It's not Hurricane, it's Hurricane. Okay, you want to know that you're an outsider? Okay, no, you say, how you doing? I'm from Hurricane. Right, Dallas. All right, it is spelled the same. Okay, here's the issue. We have a U.S. Supreme Court case called Iowa versus Knowles that basically states that simply issuing a citation does not give you permission to search the person as incident to arrest unless you have the arrest. The other problem here, there's no arrest here, right? And a citation, look, when you say a citation is in lieu of arrest, I mean, okay, where does that get you though, right? I mean, in a lot of states, you can arrest people for no license. But a lot of states, a lot of cops are not arresting people for no license. They're letting them go. So sure, let's call the citation in lieu of arrest. Does that mean we can search people from top to bottom because we could have arrested them but didn't? No. So that's the first problem, right, Dallas? Right? And here's the other problem. Is there any probable cause? Is there any probable cause that this person has evidence on their person? Right? Just like you said shopping theft, retail theft. Hey, I'm good with recovering the evidence, right? But if it's just probable cause for something that for them using their fists, well, I guess you can seize their fists and chop off their hands as evidence, but I don't see how you get into their pockets. All right. So I think we're good. All right, I wouldn't be doing it. I think it blatantly violates the Constitution. Okay, Mark, my friend Mark from California. Best practice recommendation for pursuing misdemeanor suspects into residence in light of Lang versus California. Okay, man, Lang really throw us a curveball, guys. I got to tell you that my money was kind of on the other side of that case. I'm usually not wrong about Supreme Court cases, but that one I was a little wrong, right? Yeah, sorry, Rick. The internet's kind of crappy. Actually, the internet's been really crappy. It's even cell service. All right. Hey, let me. Hey, Rick, should I turn off my video? You hear me okay? I can turn off my video. It will help. But if you can hear me okay, I guess having the video is better than nothing. So let me just kind of share with you what's going on with Lang. Lang is a Supreme Court case that just came out a few weeks ago that states that in order to chase somebody for under hot pursuit, right? Okay. So let's see if that helps, Rick. You let me know if it helps, Rick. So in order to chase somebody under hot pursuit, you have to have a couple things. One is a felony. Any felony, okay? Any felony will allow you to enter a home under hot pursuit, right? Or if it's a misdemeanor, you got to have some form of emergency, some kind of law enforcement emergency. The person will escape before you get a warrant. The person will destroy evidence. The person will be a public safety risk. If you do not have that, then you can't chase them into the home. In other words, let me just put it this way. If you have an opportunity to get a warrant and there's nothing else that's going to happen before the warrant arrives, you can't chase him into his home. So my suggestion is this. Number one is don't forget that oftentimes if you do not enter the home and you go get a warrant, they can go out the back door, right? Right? They can go out the back door. So that's the issue. Don't forget if they have evidence on them, they can destroy it. But as far as that goes, we're gonna need some more case law to define exactly kind of what we're talking about. Does that help, Mark? Even a little bit? All right. Yeah, sorry, Rick. I don't know what's going on. I think the main issue. Here, Dallas, it's this right here. It's Iowa versus Knowles, like this. All right. Okay, let's go through this now. I'm going to turn off my video while I talk this one. So I think that's going to help too. Again, my internet's a little slow here, but we're going to keep going, right? Can police open a car to check the VIN on a vehicle, right? A car door. Man, again, this is, just me quickly trying to put this together, okay? Let me tell you what the situation is. So this is from an officer in Utah, right? A vehicle was parked in a parking lot of a bank. No plates was visible, right? No plates were visible, but the VIN was visible through the windshield. Another officer had opened the door and verified the VIN in the door jamb. Could this be a violation of the Fourth Amendment? Or is this something that could require reasonable suspicion? So can cops, if they see the VIN on the windshield, can they also open the car to verify the VIN on the placard? Yes or no? All right, I got your answer for you, and I'm 100% positive. Okay, you ready for the answer? And I'm 100% positive. The answer is no. You cannot open the door. Here's why. The person has no reasonable expectation of privacy in the VIN. We all get that, right? That is a case called New York versus Class. However, the court said there that you still have to have lawful access to the VIN placard on the door. In the New York case, what happened was the placard, the VIN on the dashboard was covered up, right? And it made sense for the cop to open the door to verify the VIN or to move the papers around and so forth. But if the VIN on the windshield is not covered up, there is no legitimate reason to open the guy's car door, right? That would be a search under the Fourth Amendment, and you need an exception for that. Now, if the VIN is stolen, the car is stolen, open up the car. If the VIN looks like it's a fake VIN, open up the car, right? But it's not enough that just because you want to look at the VIN. Here's the case law. We note that our holding today does not authorize police officers to enter a vehicle to obtain a dashboard mounted VIN when the VIN is visible from the outside of the automobile. If the VIN is in plain view of someone outside the vehicle, there is no justification for governmental intrusion into the passenger compartment to see it. Another case. A driver who has committed a traffic violation does not have a reasonable expectation of privacy in his vehicle's VIN, even if it is not in plain view. If the VIN is visible, though, that's the point. We understand that. We understand that the VIN itself is not a privacy interest. However, they may have a privacy interest in where the VIN is. If the VIN is visible from outside the vehicle, the officer cannot enter the vehicle to read it. If the VIN is not visible and the driver is inside, the officer must ask the driver to remove any obstruction and allow him to see the VIN. We can go back and forth on that one, but if, as in this case, the VIN is on the dashboard, is covered, and the driver is not in the vehicle, the officer may open the door to read the VIN on the door jamb, just as the trooper Kennedy did. He may ask the passenger to remove the obstruction, or he may reach into the vehicle to remove it, and so forth. So the takeaway here is that opening a door to look at VIN placard must be justified. Any questions on that? Are we good? Good. Okay, Patricia. Thank you. All right. So next question. Awesome, Charles. All right. Can an officer run a person's name for warrants who is not detained? So here's the scenario. This is from an officer in California. If an officer sees a known subject walking down the street and runs his name for warrants, is that a search under the Fourth Amendment? Well, you guys know that question. You know that answer, right? What's the answer? Mm-hmm. Yeah. Yep. Yep. That is not going to be a search under the Fourth Amendment. Running a person for warrants is not itself a search, and therefore doesn't implicate the Fourth Amendment, right? And Patricia says can run them for LA purposes. I do like that, because if the officer is running like the babysitter and running neighbors, that may not necessarily violate the Constitution, but it violate NCIC rules, right? Is that what you're talking about, Patricia? Okay. All right. Our last question of the day that I have for you, and if you have any more for me, I'll stick around. But here's the last one. Okay, guys? Can police automatically enter a building based on nothing more than an alarm call? Okay. So here's a question from an officer in New Jersey. Officers are called to a residence for an activated alarm. Officers check the property and find an unlocked door. There is no signs of forced entry and everything appears to be normal. Do officers have the authority to enter the residence to determine if the criminal activity occurred? It is, and it has been our agency's policy to search any residence or business we locate with an unlocked door to determine if a crime occurred. And I'm trying to determine under CREW, which is what I teach cops, consent, recognized exception, or warrant, what exception would permit this? I'm leaning towards community caretaking. However, what is the articulated emergency? I also look at it as when a person registers their home business alarm with a monitoring company, they should know that the police will be summoned if the alarm activates. With this knowledge, they're indirectly calling the police to their residence to investigate the alarm. Would this give us the authority to enter the residence or the building, right? So I sincerely appreciate any advice. Anthony, you are the best thing that ever happened to law enforcement. and I wish you and your family the best. That last part might not be so true. All right. So, so here's the deal. Okay. Let me get on this one. Okay. Here's the deal. I am a alarm plus person. What I mean by that is I do not enter homes, businesses simply because the alarm is going off. That's me. That's how I roll. That's the Bandiero method. Because most of the alarms in my career, when I was a trooper, a police officer, and so forth, were false, right? Were false. And it's not worth it to me to go into this residence, business, whatever, and scare the business owner, you know, and get into a shooting because he pulls a gun on me because he's shocked that the police are there and he didn't even know the alarm was going off, right? It's just not worth it. And again, under Winnebago County, DeShaney, you don't have no obligation to enter that building, okay? I'm just telling you. So that alone is not how I roll. I am a alarm plus person. What do I mean by this, right? Alarm plus strange car in the driveway. Alarm plus somebody's home, but they ain't answering the door. Alarm plus neighbors say, hey, they're on vacation. Alarm plus signs of forced entry. Alarm plus this neighborhood has been hit hard with daytime burglaries, right? That's the type of stuff, you know, that I'm looking for, right? I'm not saying you can't go into the backyard and scope it out and so forth. There is an argument. The officer is actually very smart about talking about this implied consent, right? Implied consent argument. There may be an argument that the homeowner, since he or she has signed up with the ADT alarm system, and he or she should know that they're going to contact the police department, that they should know the cops are going to arrive. But that doesn't necessarily mean that they expect the police to enter their home with their guns drawn and clearing it. I mean, that just means they're going to show up and investigate, right? That's how I feel about it. So let me just kind of give you a case that maybe kind of helps make my point too. So here, the court said, look, police officers did not have objectively reasonable belief that entry into the home of defendant's parents was needed to render emergency assistance to injured occupants or to protect occupants from imminent injury, and thus the officer's warrantless entry was not justified under emergency doctrine. Mere triggering of alarm did not, by itself, present emergency situation because such alarms were usually false alarms. Defendant was openly working on a van and driveway when the officers arrived. Defendant had a key to the house and there was no sign of a break-in. So this is not, you know, this is not necessarily on point because the guy was like, you know, again, he was like, dude, this is my parents' house. I'm sorry I set the alarm off, but I'm trying to work on my creeper van here. You know what I mean? I got a new candy dispenser in here, got some new playing cards and stuff like that. You know, just leave me alone. And so again, it's not directly on point where there's nobody around, but it does make the point that even the courts are acknowledging that, hey, a lot of the alarms are false, right? And be careful, right? So my takeaway on that case is have alarm plus. If you have alarm plus something else, I think you should be okay. My friends, we've been going at it for an hour and 20, almost 30 minutes. Have you found this information useful? And do you want me to keep doing stuff like this? Okay, right? You got to give me feedback. If this is boring, if this is a waste of your time, or this is not helpful, then I want to do something else, right? Right? Maybe I got to spend some time with my kids. They're growing up quick, right? And they're even my kids. So I should really want to play with them. You know what I'm saying? Okay, good.
When it comes to law enforcement training, we are the gold standard. Visit bluetogold.com or call 888-579-7796 to learn more about our training, books, and free webinars. Also, don't forget to like, subscribe, and share this channel.